Hello everyone and welcome to Uncivil Law. For today's story, we have a decision from the Court of Appeals for the Third Circuit. This is the case of United States of America versus Michael Lewandowski. In this case, Michael Lewandowski went to the FBI to report extortion against him. And as the FBI was investigating this, they came into information that he might himself be conducting criminal activity. So the interrogation went from figuring out why he was being extorted to figuring out his criminal role. He then went on to be sentenced for his criminal misdeeds, and he is suing on the basis that his confession was not voluntary. So we're going to read the case, read the decision, and figure out why, when you're talking to the police, you should always have a lawyer. Let's read on. After Michael Lewandowski went to the police station to report that he was receiving extortionate threats, the police questioned him extensively about why he was vulnerable to extortion. As it turns out, Lewandowski, a pharmacist, had been filling fraudulent Oxycontin prescriptions. He later was tried for distributing a controlled substance. He moved to suppress the statements he made at the police station, arguing that they were inadmissible because no one read him his Miranda rights. The district court denied the motion, and he was ultimately convicted. As we're going to be discussing in a little bit in more detail, Miranda applies in custodial interrogation. So in order to be read a Miranda warning, two things need to be true. You need to be in custody, and there needs to be an interrogation. To be in custody means you're not free to leave. To be in interrogation means that they're asking you questions or otherwise probing you for information. So both these things have to be true. If they're not both true, Miranda does not apply and they don't have to give you the warning. So we're going to read on about why Miranda was not given and why it was not necessary. Lewandowski appeals the denial of his motion to suppress. After careful review, we conclude that he was not in custody and therefore no Miranda warning was needed. Lewandowski was a pharmacist who owned two independent pharmacies in Medford, New Jersey. Around March of 2013, Lewandowski told two of his customers, Matthew Larson and Donna T. Jones, that he could no longer fill their Oxycontin prescriptions. On June 18, 2013, Lewandowski received a series of threatening text messages saying things like, "Think about it, you're in too deep. Loyalty is the key. There's no I in team. Please consider my wishes or I'm forced to take other routes. It may be very detrimental. And I guess we're playing hardball. I really think you shouldn't sit and think you got a lot of dirt on you, Mike. And boy, you got a lot going on." Lewandowski also received a letter hand-delivered at his pharmacy that said, "No one is safe unless you meet our list of demands. Not your kids, family, you, your employee Dave." The letter demanded thousands of Oxycontin and Adderall pills, listing dosages and types, and $20,000 in cash. So this pharmacist apparently was caught up in a drug ring where he was filing knowingly fraudulent prescriptions, and as a result, when he said, "I'm going to start cutting you off," they took it not kindly, and so he's now being extorted. Let's see what happens next. Lewandowski contacted his uncle, a New York FBI agent, who in turn called in FBI's Trenton office. As planned, Lewandowski drove to the police department on June the 24th. He was interviewed beginning around 10:15 in the morning and remained at the station until 5:30. Because Miranda versus Arizona requires us to determine whether Lewandowski was in custody, given the totality of the circumstances, we recount the interview in some detail. Detective Nietzsche and FBI Special Agent Stephen Montgomery interviewed Lewandowski in a small 8-by-8-foot room that contained a round table and 3 chairs. It had the atmosphere of a bare-bones conference room with carpet on the floor and typical office furniture. Lewandowski sat closest to the door and was not physically restrained. He was given water, which he drank, and offered pizza, which he refused. He went to the restroom unaccompanied at least 3 times. However, he asked permission before he went. Out of the 7 hours Lewandowski was at the station, he was interviewed for about 4. So this sounds like your typical run-of-the-mill interrogation room. Interrogation rooms are small. They're meant to create a series of unease. So they're small to get you to confess. So, they're filled with furniture to make things a little bit more cramped. It's designed to be physically imposing. So you want to leave, and therefore it induces you to say things that will be, revealing. So this is like a standard interrogation room. It's very bare bones, so there's nothing interesting to look at. It's very, very plain. It's very small, and it's just designed to create you an environment which is conducive to the interrogation. So run-of-the-mill interrogation room. When you walked into here, you should have understood things were not going well. In the first portion of the interview, the officers obtained background information on Lewandowski and learned about the threats he had been receiving. Just before the first break, Detective Nitsch and Agent Montgomery spoke to each other briefly, and Agent Montgomery said to Lewandowski, "We'll be right back. Excuse me, do you need to use the bathroom or anything?" Lewandowski asked for a drink of water and then left the room and re-entered with water. So we have phase one of the interrogation. The get to know you comfort phase of the interrogation. Well-known police tactics. Most interrogations start without the subject matter at hand. Now, of course, there are exceptions to every rule. But especially if you have this person, they're not really aware of what's going on. You didn't arrest them and bring them down. It's a little bit more discontinued. This is very typical interrogation tactic. It's get to know you. It's build comfort. So most interrogations start very casually. They start not on the topic at hand. It's very sort of get to know you preliminary stuff and you're from wherever? Oh, I went there once on a vacation. Whatever. It's building rapport. It's building rapport that you can use throughout the interrogation, right? So that makes sense. We had phase one of the investigation. Very casual, get to know information we're interested about. You came down to report this extortion. So we're going to ask information that goes to the issue that you want to talk about. We're here to talk about what you want to talk about. We're here to make you super comfortable, and we want to talk what you want to talk about. So this is all part of the standard. That's phase one. Let's talk about phase two. The officers returned 20 minutes later, at which point their style of questioning shifted. Rather than listening to Lewandowski and asking clarifying questions as they had during the first phase, they asked pointed questions and suggested Lewandowski knew more than he was saying. Pro tip: when the police come and ask you to talk to them, bring a lawyer. Even if you're the victim of a crime, bring a lawyer. Just for the hell of it, just bring a lawyer, because you never know what they're going to ask, and the lawyer's there to help. So if you're talking to the police, even if you're the victim of the crime, bring a criminal defense lawyer, please. Just bring them there. It'll be great. It'll save you a lot of problems. Just do it. Please. Thank you. Detective Nitsch focused on the message that said, "I got a lot of dirt on you, Mike." When Lewandowski posed that the dirt might be a lie, Detective Nitsch responded decisively, "No, not a lie, Mike. Mike, stop. Everyone's done something and messed up. Everyone makes mistakes. What goes through your mind immediately when they say, 'I got a lot of dirt on you, Mike'?" Classic interrogation tactic. This is run-of-the-mill, classic, textbook interrogation stuff. Lewandowski eventually answered, "The only thing I kind of thought it was prescriptions." Agent Montgomery replied, "Well, that's what we were thinking." Whether they were thinking it or not, up to that point, confirming what you just said is a good police interrogation tactic. What does dirt mean? This is basically like cold reading tactics, right? Use general things to get stuff that you can then use to make specific, right? So it's basically the same stuff that mediums use in cold reading. I'm getting a J or J sound, and you say John, and then they say John, blah, 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 and you forgot. They started out with the broad statement. All you remember, it's well documented. All you remember is the specific thing. Oh, they said John. They came with John. They know. Well, they didn't. They started with a broad statement. The FBI is doing the same thing. It's basically the same tactic. You start out with a broad thing. What does dirt mean to you? And they say, well, it means prescriptions. Oh, well, that's exactly what we were thinking. How interesting. Tell us more about the prescriptions. And then you say, oh my God, the FBI knew about the prescriptions the whole time. Cold readers of the FBI interrogators, using the same tactics, kids. Detective Nitsch added, It sounds like you might have been, filling scripts for these guys. That would piss them off if you're not doing it. You have been doing it for a couple of years. Lewandowski asked probably. Again, this could just be a guess. He's a pharmacist. They're talking about dirt. He just mentioned prescriptions. So yeah, it could just be a guess. And it would be a reasonable guess, right? Interrogators make guesses. And if you hit, they remember the hit. And if you miss, there are ways like cold reading to make sure that they don't remember the misses. Cold readers and the FBI are all about making you remember the hits and forgetting the misses. So they seem omniscient. Same strategies. So, John Edwards, FBI, kind of wanted the same thing. A few minutes later, Agent Montgomery said, "So it appears on the surface that, to us, you could have been working with these guys. Now we're giving you an opportunity to tell us the truth." Lewandowski answered, "I was not. I didn't have involvement with anybody." The officers also noticed that Lewandowski was making around $16,000 a month filling Oxycontin prescriptions for cash. They said that would cause a lot of people not to ask questions because it's very lucrative, okay? Lewandowski continues to focus on his former employee, Wood. In response, Detective Nitsch said law enforcement was willing to do whatever we need to do to help you and try to help you and your family, but that Lewandowski needed to cut the nonsense. So the officers are appealing to his family, right? They're appealing to his empathy and saying, you have other people that need to be protected. And, for us to protect you, we need to understand what's going on. This is all meant to induce you to tell them things. The FBI is very good at this, as you might imagine. Please bring a lawyer with you when you're talking to the police or FBI. It's a good idea. After some time, Detective Nitsch told Lewandowski, "September 2010, I opened an investigation on you that led to the arrest of several people." He went on to emphasize that Lewandowski was the subject of the investigation and Lewandowski's past activities had gotten him into trouble. But the fact of the matter is, you're not aware a lot of this, Mike, because you were part of the investigation. You were someone we were looking at and your involvement, okay? Now, after you've been doing this for the last 2.5, 3 years, it's come back to bite you in the ass because now you have someone or a group that someone are willing to do harm against you and your family. Again, not clear if this is actually true or not. One would imagine that if the FBI was aware of this in 2010, that they might have arrested him some point prior to 2013. So it seems like it's more indicative of bluff than of truth, but of course it could be truth, and that's the whole point. It's like you don't know either way. And so it could just be a prod, an offer, a reasonable guess to induce something. And if it's a miss, great. And if it's a hit, great. Either way, we can deal with it. So were they investigating in 2010? Who knows? But either way, it's good interrogation tactics. Detective Nitsch also told Lewandowski that taking these scripts, and not doing the checks that you should have done, it's not criminal. I'm not going to arrest you for it, okay? Yeah, as to the taking of legitimate scripts and not checking, that's probably not criminal, yes. And so they're not going to arrest him for that. Right. That's not criminal. They're going to arrest him for other things, but they're not going to make that point particularly clear. They're hoping that they'll hear, "We're not going to arrest you for it," and he's going to interpret that as, "We're not going to arrest you, period." That's not what they said, but, that's what they're hoping you'll hear, and so that you'll be more relaxed. Good strategy. For those of you with me who are not college football fans and may not be aware of why I'm wearing this particular shirt today, I would just like to take a moment to say my Clemson Tigers victoriously destroyed Ohio State yesterday in the semifinals of the National Championship of Football in a very close game. I'm extremely happy about this. Go Tigers. So I'm wearing my Clemson shirt because my Clemson Tigers are victorious. Huzzah! The second break lasted 90 minutes. Then Detective Nitsch returned alone and resumed the interview without any explanation for delay. He asked, "Anything you thought about while you're sitting in here for the last little bit that we were out there?" Good general opening question, just good. Just anything else you want to tell us about? I'm sure he's got questions of his own, but, hey, you've been sitting here for 90 minutes. What's been going through your mind? Anything you want to tell us about? It's good strategy, man. These guys are actually good. It's like they've done this before. The tone of the interview shifted again after the second break. Lewandowski made a series of lengthy statements about his circumstances and motivations, becoming emotional at times. He said he stopped filling narcotics prescriptions because the constant, every day, people coming in was relentless. The third break began abruptly. An identified detective opened the door just as Lewandowski was tearing up while saying, "I want my kids to be safe." Detective Nitsch said, "I'll be right back," and walked out. He brought Lewandowski more water and then left for nearly an hour. Upon his return, he again gave no explanation, but said he was ready to go to the pharmacy with Lewandowski, as they had discussed. The two men left the station. Lewandowski drove himself to the pharmacy. Lewandowski also signed a form that day authorizing the FBI to record his telephone communications. The extortion case was eventually solved. Dante Jones and Matthew Larson were charged and pleaded guilty. So the FBI actually did investigate the extortion and actually did prosecute and convict the extortionist. So that's good. But of course, that's not the end of the issue, because the pharmacist himself, through his confessions, has given the FBI some information that can be used against him. And now he's facing jail time too. Let's discuss further. In November 2016, over 3 years after the interview at the police station, Lewandowski was indicted on 6 counts of drug distribution, 2 counts of maintaining premises for drug distribution, and conspiracy to distribute drugs. He filed a motion to suppress the statements he made after the first break during the 2013 interview, arguing he was in custody and should have received Miranda warnings, and that his statements were involuntary. After a day-long evidentiary motion, the district court denied the motion. Manitoban Misanthrope says, "This just proves my thoughts on the police. Don't talk to them ever." Well, that's a pretty good tip. I would recommend modifying slightly by saying don't talk to them without a good criminal defense lawyer. You know what? A criminal defense lawyer, someone who actually goes. So as much as I personally would like to represent you, I'm not a criminal defense lawyer and don't necessarily believe I could do the best job for you. So you should get a criminal defense lawyer, someone who actually practices in this area. Say, the police want to interview me. Will you come to the interview? And they will say yes. And then you will have a meeting in advance, and they will ask you all the stuff that the FBI will in first, so they know the answers to the questions the FBI will ask. And then they will be prepared, and they will say things like, "That's the end of the interview," when they ask the question, because they will know what the answer is. So, bring a lawyer along when you talk to the police, please. The jury found Lewandowski guilty of 5 of the 6 drug distribution charges and 1 of the 2 premise charges. It acquitted him of the conspiracy. At sentencing, the district court found by preponderance of the evidence that Lewandowski had acted in concert with others. It sentenced him based on hundreds of fraudulent prescriptions rather than the 5 associated with the count of the conviction. By Lewandowski's calculation, the consideration of the additional prescriptions put his sentence into the 151 to 188 month range, rather than the 51 to 63 month range. The court ultimately sentenced him to 180 months. He appeals. Statements made to the police can be used against you. Very, very against you. Enjoy your time in prison. Lewandowski argues the district court erred in denying his motion to suppress the statements he made during the June 24, 2013 interview. He contends that his statements are inadmissible because he was in custody and therefore needed Miranda warnings, which he did not receive. Under the Miranda rule, the privilege against self-incrimination is jeopardized and warnings are required when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subjected to questioning. Custody is a term of art that specifies circumstances that are thought to generally present a serious danger of coercion. To determine whether an individual was in custody, first we establish the circumstances surrounding the interrogation. Then we ask, as an objective matter, whether a reasonable person would have felt that he or she was not at liberty to terminate the interrogation and leave. So when you're looking to custody, the issue is freedom to leave, whether real or perceived. And so you're looking to things like, well, would a reasonable person in the situation feel like they could leave? Did they say you're under arrest? Did they say you can't leave? Did they lock the door? Did they physically restrain you in any way? Or did they allow you, for example, to go to the bathroom by yourself? Did they allow you to eat and drink if you want? Did they leave you unaccompanied in an unlocked room for long periods of time? These would be things that would suggest more that you had freedom to leave. And if you had just left the door, you could have. So that's the kind of issues they're looking at. The court found there were never more than 2 questioners in the room with Lewandowski. No one blocked his exit, and officers used some salty language, but nothing out of the ordinary for a police department. The meeting overall was businesslike in tone. There was no posturing or shouting or pounding of fists on the table or any display of emphatic behavior. The court noted that 7 hours is a long time, but added there were 2 breaks and that Lewandowski had his cell phone and his normal clothes. Finally, the court observed that Lewandowski never indicated once he didn't want to answer questions. Instead, he gave hesitant answers or inconsistent answers. His demeanor on tape was that of a person who was deflecting the questions or pretending not to know the answers. We then move to the second step of the Miranda analysis and ask whether a reasonable person in Lewandowski's circumstance would have felt free to go. Numerous factors help answer this question: the interviewee's location, physical surroundings and duration, whether he voluntarily participated, whether he was physically restrained, whether other coercive tactics were used, such as hostile tones of voice or displays of weapons, and whether the interviewee was released when questioning was over. We also consider whether the questioner believed the interviewee was guilty, whether the interview was specifically told he was not under arrest, and whether he agreed to meet knowing that he'd be questioned about criminal circumstances. So here the court is laying out multiple factors that can go to saying whether someone is in custody, which is to say whether or not someone feels free to leave. And there's a whole bunch of factors that can lead to that kind of conclusion. Now, not one of these things is dispositive, of course. They're all elements that a court can take note of in trying to determine whether or not a person is feeling free to leave. So these are guidelines. And you look at these elements and say, well, what factors are here, and would a person feel free to leave in this situation? And would a reasonable person feel like they could leave or had the ability to leave? And that's the question you're trying to leave. And that's the question you're trying to answer. To start, Lewandowski was not physically restrained. He did not feel an obligation to come to the questioning. And given the circumstances, we agree with the district court's finding that Lewandowski knew he'd be questioned about the reasons behind his extortionate threats, including his own possible criminal activities at the pharmacy. All these factors tend to show he was not in custody. The officers told Lewandowski they thought he might be filling fraudulent prescriptions, and when officers have more cause for believing the suspect committed the crime, there is a greater tendency to bear down in interrogation and create the kind of atmosphere of significant restraint that triggers Miranda. Here, though, the officers were trying to get to the bottom of extortion, so they needed to question Lewandowski about the subject of the threats. Therefore, the questions about Oxycontin distribution do not show coercion associated with the custody. Zafale asked, dispositive, wouldn't that be negative? Not necessarily. To say something is dispositive is simply to say it disposes of the matter, but doesn't say which way you're disposing of it. It just simply solves or answers the question. To say something is dispositive is to simply say we can dispose with asking the question because now we know the answer. So dispositive, at least in the legal sense, does not imply a negative or a negative connotation where we're saying it means it doesn't apply. It just means we know the answer one way or the other. So if we say, oh, this factor is dispositive and therefore says it's not something, or this factor is dispositive and therefore says it is something, either way it disposes of the question we're trying to ask. So thank you for the question. Evil Coleslaw says, it looks like he opened the books to them too. If they knew the interview, he's making $16,000 on cash. Well, I don't know whether they actually knew that number or whether or not they just threw out a number. I don't know whether that was a guess or an actual number. I don't know if they really were investigating him beforehand and did something or whatever. Maybe they threw out a number just to throw out a number and on the thought that they'd correct him. Maybe they said, we think you're doing $16,000 of business. And they'd say, no, I only did $4,000 of business. And therefore, they'd have a question as to 4. So I don't necessarily know that because they said 16,000, that was an actual number as opposed to a made out number. But either way, it didn't matter because he confessed to the crime. So It worked. Great. Considering all these factors, the district court did not err in concluding that a reasonable person in Lewandowski's situation would have felt free to go. But even if we concluded the opposite, our analysis would not end there. Constraints on freedom of movement are necessary, but not sufficient condition of custody. The individual must also be subject to the same inherently coercive pressures as the type at the station house, questioning the issue at Miranda. So here the court is pointing out that one factor that you can look at is whether or not you felt free to go. And while that is necessary, it is not sufficient because you're looking to overall coercive effect. So you're looking to overall issues of custody. So not feeling free to go is necessary to be in custody, but not necessarily sufficient. And so you need to look at other factors. So let's read on. Lewandowski next argues that his incriminating statements should have been suppressed because he did not make them voluntarily. The issue is not resolved by virtue of our conclusion that Lewandowski was not in custody. In special circumstances, a confession might be involuntarily, even if the person is not in custody. Because you're looking to overall coercive effect, just because they're not in custody might not necessarily be a trigger. You could have a situation where the police are putting so much pressure on you or so much stuff that even though you're technically free to leave, that it still is unduly coercive. It basically shocks the conscience. And so that might be enough for suppression. Did that apply here? Let's read on. Zafel, I wouldn't necessarily recommend skiing and watching the stream at the same time. That seems like a bad plan. But whatever. The government has the burden to prove by a preponderance of the evidence that Lewandowski's statements were voluntary, that is, the product of essentially free and unrestrained choice. There can be no involuntary confession absent coercive police activities. We conclude by observing that Lewandowski is a mature and educated, sophisticated business owner who is in sound mental and physical health at the time of the questioning. Lewandowski's statements at the police station were voluntary. So that is the end of the case of United States of America versus Michael Lewandowski. In this case, we learned that Mr. Lewandowski was a pharmacist and was being extorted because he was no longer filling Oxycontin prescriptions, including ones that he was fulfilling for cash money. And therefore, he revealed his part in the drug plot and was sentenced to 15 years in jail. He moved to suppress the evidence against him on the basis that the coercion was so improper as to require a Miranda warning, but the Court of Appeals disagrees, noting that the door was not locked, noting that he was free to go, noting that he was allowed to go to the bathroom by himself, and otherwise that he had his cell phone with him and could, and in fact did, make some phone calls during the interrogation, so that he was not under custody, and therefore Miranda did not apply. They did not need to give a Miranda warning, and all the evidence can be used against him and was used against him to the tune of 15 years imprisonment, and that is the end of this case.